Mr. President, I wanted to come to the floor to talk about the Shelby Amendment. I think we have to be 100% clear about one thing, and that is that we need to pass a consumer protection bill, not a Wall Street protection bill. A strong, independent agency that can aggressively defend families in all sectors of the financial industry. That's consumer protection. A weak agency that can't defend families against commercial banks, investment banks, credit card companies, car dealers, payday lenders, and entities like AIG, that's Wall Street protection. And that's what, in essence, this amendment does. The fact is that the Republicans' proposal on this amendment seems to symbolize America's worst fears about how the powerful operate, the powerful protecting the powerful. The problem isn't that families have too much protections on Wall Street. The problem is that they haven't been protected enough. The Shelby substitute is just the status quo. It's a cynical attempt to pretend that they're doing consumer protection. In reality, it's meant to make sure that there's no meaningful consumer protection at the end of the day. It willfully ignores the lessons that we should have learned, that left to their own devices, there are lenders who can and will take advantage of consumers. That's what the marketplace, as it is right now, has taught us. We absolutely need a muscular, independent agency, however it's configured, wherever it's housed, one that will have full and comprehensive authority to develop and implement real, honest, pro-consumer rules so that they will no longer be fooled by 30 pages of fine print no one except the bank lawyers could possibly understand, one that has independent rule-writing authority and authority over banks and non-banks while maintaining strong state consumer protection laws, one that will stop the ongoing attempts by credit card companies to circumvent the rules that this Senate and this Congress have already enacted. They're already working at it. As Harvard Law professor Elizabeth Warren has noted, thanks to product safety rules, you can buy a toaster that won't burn down your house, but you can buy a faulty mortgage that can take your house away. And the bank regulators have been of no great help because they're looking out for the banks, not for us, not for you, not for unsuspecting families who need the full force protections of robust regulations implemented by a muscular agency that's on your side. So in my view, a new independent agency would provide not only the comfort they need, but the protection that they deserve. Now, we can argue about details, but I doubt there is much disagreement after what we have been through that Wall Street needs a watchdog, one that has jurisdiction over all financial products, no matter who offers them, not just the products offered by big banks. Chairman Dodd has worked very hard over many months to craft the details of an agency that strikes the balance. And I was really happy to see that finally our Republican colleagues were saying, we're on the Wall Street reform train. But now I begin to wonder when I see amendments like this that they jumped on the train to strike the emergency brake on consumer protection enforcement. The Shelby Amendment offers nothing in the way of consumer protection. There's no independence. The CFPB would simply be a division within the FDIC with no autonomy of its own. It wouldn't even finalize a rule without FDIC approval. It will not have any resources, and that's how Republicans want it. No resources, no supervisory authority, no enforcement power. Guess who wins in that scenario? Non-mortgage companies will never be subject to the supervision unless they have a pattern or practice of breaking the law within the past 3 years. So what does that mean? Let's have a lot of people get hurt before we actually would say that we should now give them protection. It's not my sense of how the law should operate. The Shelby Amendment would establish the Division of Consumer Protection of the FDIC. It maintains, in essence, the status quo. Consumer protection rule writing will still be under the same authority, the same regulators who routinely ignored or opposed the needs of consumers. No safeguards to prevent the FDIC chair or board from overriding decisions by the division director. The amendment would actually prohibit the proposed consumer division from doing any rule writing under the Federal Trade Commission Act for payday lenders, debt collectors, foreclosure scam operators, mortgage brokers, other non-bank consumer finance companies. It could only do examinations of non-bank consumer companies if they demonstrate a pattern or practice of violations of consumer law. So only after the consumer has been harmed could they repeatedly, after they've been harmed repeatedly, could the consumer division do any examination of the business. This is just simply saying, you know, I'm going to tell you that I'm going to put a cop on the beat. He's got no uniform, he's got no equipment, and he can't stop the bad guys. What a falsehood. We need to defeat this amendment, and we need to have a bill that ultimately gives strong consumer protections for millions of families in this country who have already faced the consequences of the system that is going on unregulated in a way that it allows greed and excesses to take place and that puts protections, yes, for Wall Street, but not for Main Street. Senator Dodd has struck the right balance. We need to preserve it, and I look forward to supporting him and opposing this amendment. And with that, Mr. President, I yield the floor.